Good morning, everyone. My name is Maria Cristina Valencia. I am the founder and president of the club. Thank you for being here one more Wednesday. As you guys know, we try to bring you very valuable information every week so you can be a better professional, help your clients, assist them, and therefore get more referrals from them. And today is a class that actually I've been waiting for a long time because I want to know more about this topic. I don't know much about it, or I think that I can learn a lot more. And we have a true professional with us and he's been so kind to share his knowledge and his time. Michael Heath is here with us, and he's going to explain the different types of deeds, the difference between ladybird deeds and probate and all that. So please take notes. And as you take notes, of course, we always have a few minutes at the end of the class so you can ask questions and bring all this value to your clients. So thank you so much, Mike, for being with us today. Let me know when you're ready so I can share the screen with the information that you sent to me.
Sure. Thank you, Christina. My name is Michael Heath. I'm a real estate attorney and probate attorney. I work a lot with realtors and brokers throughout Florida. One of our core services is facilitating realtors with probate transactions. And Christina asked me, and I appreciate the opportunity to speak with all of you about ladybird deeds and the probate process. Let me first kind of discuss a little bit about deeds. So for those of you that don't always understand the different types of deeds, let me go through them briefly. So a ladybird deed is one and the same as an enhanced life estate deed. And Christine, if you could pull up that verbiage that I sent to you by email, and if you can, I could read, and I'll summarize it as she pulls it up. A ladybird deed is a deed essentially that works like a transfer upon death deed. And you're going to see language in that type of deed that says something to the effect of that the life tenant has complete power and authority to be able to sell, convey, dispose, or otherwise transfer the real property. Okay. That's the similar language that you'll see in that type of deed. So you have a ladybird deed, you have a warranty deed, a quick claim deed, and a special warranty deed. So before we talk about ladybird deeds in more detail, let's go through what each one of those deed types are. The general warranty deed warrants ownership to the buyer and all subsequent buyers of the property, that you warrant your ownership to them. A special warranty deed says, I warrant my ownership to you, buyer, but only to you, buyer, and not all future buyers. A quick claim deed says, if I own anything, I give it to you. It doesn't warrant any ownership. And so those are the common deed types. And a lot of people, just for you all to know, a lot of people say, well, we'll just get a quick claim deed. A quick claim deed, generally speaking, is only a type of deed used to fix mistakes. So you generally don't want to use quick claim deeds. And if you hear your clients saying, well, we'll just quick claim it, you don't want to do that type of deed. It's often very suspect for title examination purposes. And there's a variety of reasons why we don't want to do it. One of the biggest reasons why we don't want to use quick claims is if your clients have an owner's title insurance policy, it invalidates their owner's title insurance policy. Okay. So that's a big thing. And now, if you don't own a piece of property and you're fixing a title mistake, well, then that's what you're supposed to use as a quick claim because you don't have title insurance. But if we're really transferring a property such as, well, I'm transferring it to my LLC, okay, or I'm adding my, spouse to title, I'm adding my girlfriend to title, I'm adding my child to title. We want to have the warranties of title in there because if we go to a subsequent closing, okay, and then all of a sudden we find out that the prior seller's mortgage isn't satisfied, and maybe it is satisfied, but there's no satisfaction of record. And for those that are in the title industry, know that that's not an uncommon occurrence. that, a lender goes defunct and we're missing a satisfaction. Well, all of a sudden, when we go to closing, we could take that title policy, like for an example, in a ladybird deed, we could take that title policy mom and dad got, and son can go to closing, and the title company will still be on the hook to be able to use that title policy to be able to close that transaction, because the ladybird deed said that the warranties of title are warranted to the son and the daughter with the ladybird deed. I know that's a finite nuance of a distinction between why we would use a warranty deed or a quitclaim deed, but the warranty deeds are better. So I always try to drive home that point between parties that quitclaim deeds are really for only fixing of mistakes.
Question
So now,
here, Mike, before you move forward, because you brought a very important a topic here. Most of our investors, when they buy and they don't have the time that for the LLC to be ready, and they purchase a property under their personal name and they close when the LLC is ready, they will do a quick claim deed within, a week or a month. Would that invalidate the original title policy that was done under? So what is the solution there? You have to do a new title policy under the new deed?
just use a warranty deed. And then once we have to file a subsequent closing, we can file a claim on that title policy because the grantee, the LLC, could make a claim against the original individual's title policy.
Okay, got it. Good to
So
know that.
that is a prime example, and I can tell you I have instances of claim situations where the title underwriter will say, "Hey, look, we're no longer on the hook on this policy anymore because the party quit claimed it." So we
Right.
have no liability to the new grantee because there was no warranty of title.
That's a big problem.
Yes, yes. And so you should not, we get hired to do deed transfers all the time into LLCs, but here would be the one reason why that investor might do a quick claim deed. I'm not saying it's a legitimate reason, but I'm telling you that it exists because they want to fraud the Department of Revenue and not collect documentary stamp tax. And the Florida Department of Revenue says if you got a mortgage on that property, you have to pay doc stamps based on the outstanding loan balance transfer from the individual into the LLC. Now, regardless of the type of deed, warranty, or quitclaim, it wouldn't alleviate the obligation to pay the documentary stamp tax. It's just not as apparent on a warranty deed, because a warranty deed would say subject to that certain first mortgage referred to in OR book and page. So it's easier to hide it from the Department of Revenue. And let me be clear, I'm not saying that we should hide anything from the Department of Revenue,
Right.
but that's why people do quick claims. I don't agree with it. It doesn't alleviate the obligation to properly pay documentary stamp tax, but I suspect that's why some people do it.
Okay.
Um,
Thank you. Thank you.
so and so we get hired for that service is to pick apart these pluses and minuses. But if you have to pay the doc stamps regardless, if that's what the law says, then you might as well have the warranty deed for the protection of the title policy. So what is a ladybird deed? So let's go back to, because I mean I could go on for a whole segment on the different types of deeds. Now let's go past the different types of deeds, warranty, quitclaim, or special warranty deed, and talk about the tenancy types. Now, tenancy types is how we hold title. So, of course, if we have an individual ownership, you don't have any tenancy type because it's an individual. But sometimes we have husband and wives, and that is another way of saying tenancy by entirety. So in some states, they will say tenancy by entirety, and you'll hear your buyer say, well, I want my deed to say, because my lawyer in Illinois says it needs to be tenancy by entirety. In Florida, we don't typically use that special phrase. We just say husband and wife, which means if husband dies, wife gets it, wife dies, husband gets it. A similar type of tenancy to husband and wife is joint tenants with right of survivorship. If boyfriend dies, girlfriend gets it. If girlfriend dies, boyfriend gets it. But what's the one plus about a husband and wife type of tenancy? In the state of Florida, we have unlimited spousal protection for assets held as husband and wife. So if you sue Michael Heath, you're not going to get anything because Michael Heath doesn't own anything. Michael Heath owns everything together with his spouse. So the only way you'll get any assets is by being able to sue Michael and his wife. So that's a special distinction only available to husband and wives, which means if there's a judgment entered against just one of the spouses at closing, we can have the parties sign a continuous marriage affidavit, and that with that judgment won't apply to a husband and wife property. That remedy and protection is not available to joint tenants with right of survivorship. So it's a small distinction, but it is a distinction. As to estate planning purposes, husband and, right of survivorship is a fine way of estate planning, but it doesn't do the same thing as husband and wife for asset protection purposes. Okay. So we have husband and wife, we have right of survivorship. So if Michael and Christina own a property, we obviously can't own it husband and wife, but we could own it right of survivorship. If Michael dies, Christina gets it. If Christina dies, Michael gets it. Michael and Christina could also own a property as tenants in common. If Michael dies, then Michael's estate gets it. What's the benefit of doing right of survivorship versus tenants in common between Michael and Christina? Well, if the true intention is Michael owns half and Christina owns half, tenants in common would be the better form of ownership, so that if I die, my family gets my half and not Christina. And if Christina dies, her family gets her half and not Michael. The plus is our families get our respective 50% shares. The downside is that probate will be required to transfer my half to my family. Okay. Now, if the deed is silent, it is presumed tenants in common. So if it just says Michael and Christina and nothing more, it's presumed tenant in common. Okay. Now, how do we protect Michael's family? Okay, to make sure we could avoid probate. So if Michael dies because he owns a property with Christina, we could use the ladybird deed. So a ladybird deed can be in the form of a 50% ownership. It could be in the form of a quitclaim deed or a warranty deed. But a ladybird deed essentially allows you to designate a beneficiary to receive your share of that property. Okay. Now, it has its pluses and minuses. Okay. A ladybird deed works in many instances, but it is not a perfect solution for everybody. Okay. So it would work if Michael says, well, Christina and I bought this property together. We're investing in it together, but if Michael dies, he wants his share to go to his wife. Okay, fine. Not so bad. Pretty easy squeezy. Mike dies. His wife gets it. We can do a ladybird deed for that 50% share in that property, and it can go to his wife. But what if Mike says, well, I really want it to go to my 7 kids. I don't have 7 kids, by the way. But if I wanted it to go to my 7 kids, well, that is a logistical nightmare. Okay. Do we really want 7 kids, of which 3 are minors, to own a 50% share with Christina? Okay. So no, that would not be a good solution. Maybe a trust would be a better solution in that particular case. So a ladybird deed doesn't work for every situation. It works for some situations. So I also do estate planning, and the various things people always say to me, they come into me and say, oh, I need a trust. Oh, I don't need a trust because of this. And I always tell people the 3 questions I get, I'll give you the spiel I give everybody for the estate planning. My job is to avoid probate. My job is to take care of any unique family concerns. And job is to do it as cheaply and reasonably as possible. But what got where you wanted to go and who were decision makers. Okay. And
Mike,
if
just
you
just
have
just to
one
hold on a
farm,
second. Hold on a second. Are you guys listening fully, or am I the only one who got frozen? Can someone let me know if it's okay on your end? Are
No,
you
it's
guys listening good?
no. We're hearing the same way as you are.
Okay, okay, Mike, we lost you for a minute. I think it was connection wise. I think you're back. Yes. So can you go back
okay,
from
I
the
apologize.
yeah, the three questions that you say to when you're doing estate planning. That's where we left off.
Sure. What do you have? Where do you want it to go? And who are your decision makers? Okay. Because what do you have and where you want it to go will dictate how, if you have 7 kids, that's not good for a ladybird deed. Okay. If you have small business interests, multiple properties, commercial properties, unique and funky assets, then that's not good for a ladybird deed. That would be better for a trust. But if you have one homestead and one, one or two kids and they get along, that's a perfect opportunity to use a ladybird deed. Okay. But if you're more complex or you have kids with, I always tell people just because you have a lot doesn't mean you don't need to have a trust. Just because you have a lot doesn't mean you need a trust. You could have $100,000, but a kid with a drug addiction, and if you gave them $100,000, they'd be dead. So it's not just that you need a trust because you have a lot of money. It might depend on what do you have. You could have a $5 million residence and a $5 million in the bank account, and you have one child. You don't necessarily need to have a trust because one person is getting everything. Prime use of a ladybird deed. One person to get it, 2 people to get it, 3 people and 3 kids get along. But a ladybird deed creates joint ownership. So the family is going to have to work together to be able to dispose of the property. Okay, so if they don't get along well, a ladybird deed is not going to be a good use for them. Okay, so you have to understand what it's used for and why we might use it and why we might not use it. What is another couple of nuances to the ladybird deed? One is it doesn't do anything for federal estate tax. It doesn't do anything for foreigners in terms of avoiding federal estate tax. Okay. So for those of you representing folks, for non-treaty countries and that's a whole nother class, Christina, we could talk about non-US citizens investing in the US. But for those that aren't aware of it, the non-US citizens can only have $60,000 in assets in the United States before they have to spend roughly 45 cents on every dollar over the $60,000 and pay that towards federal estate tax obligations. And federal estate tax doesn't care what you paid for it. They simply care over the fact that you're a non-US citizen owning an asset in the United States worth over $60,000. Let me give a little quick sidebar to that. If any of you are representing non-US citizens buying in the United States, I strongly suggest you make their contract assignable and we sort through the federal estate tax issue before they close. Once they close, they're kind of locked into those obligations. Okay, so that's my sidebar on non-US citizens. But the ladybird deed will work great for probate avoidance for non-US citizens, but it doesn't avoid the necessity to file a federal estate tax return for the non-US citizen. It's not designed for tax avoidance. It's designed for probate avoidance, which are 2 different things. Does anybody have any questions about that? Okay, let me kind of keep going on. So the ladybird deed works great for the probate purpose. So what do? Somebody calls you up, okay, and they say, Mom just died, and I want you to sell Mom's house. Okay, so you're as the realtor, you're my eyes and ears. You're my first line typically when you get that phone call. By the way, the vast majority of my business comes from realtors. So I say that because I'm in the trenches working with you guys on contracts, on closing related issues and probates. And so you get that phone call. What do? The first thing you do is you're going to go to the property appraiser's page in the county where the property is located, and you're going to see who is listed on the property appraiser's page. Okay. And then you're going to go down on the screen and you're going to look for the last deed of record. Just because the property appraiser has Mom's name on it, just because the property appraiser says the estate of Mom, you shouldn't rely strictly on the property appraiser's name and what they say. It's just, it doesn't, it's not a reliable source in this instance. Okay. So you're going to look at that last deed of record and you're going to look first to see, was it a ladybird deed? Does it contain language? Does it have the kids' names on it that says, you know, upon the death of the life tenant, the remainder has some sort of language about sell and convey or dispose of the property, those kinds of things. If it does, then you need to look at that deed and say, okay, I've got a ladybird deed. What does it say? Okay. If all goes as planned, you're going to see a deed that says, you know, mother's name upon mother's death to the 3 kids. Are all 3 of the kids still alive? Okay. Because sometimes we do deeds that say mom upon death, mom's death to the 3 kids. Now, you heard me say tenants in common versus right of survivorship. When I do a lady mom to the 3, I have a fair conversation with them over the over for the 3 kids. Do you want the 3 kids as right of survivorship or tenants in common? And they'll say, well, that's not, I'm only here for me. And of course, I have to explain to them that you have to decide, is it right of survivorship or tenants in common as to the 3 kids? Okay. So if it's right of survivorship and one of the kids dies as to the 3 kids, you're still okay because it goes to the other 2 kids. But if mom died and son died and it doesn't say anything but the 3 kids' names, we might have to probate mom and son. Okay. So you'll want to look at that deed. In addition, you may see instances that the deed is mom and son. It isn't a ladybird deed. It's just mom and son right of survivorship. And again, if you see right of survivorship, if one dies, all goes to the other one. Okay. What do you do if it's nobody? Okay, so let's assume they did nothing and they didn't do any of the proper planning the way they were supposed to, and it's just one of their names. Here's the question. So now if you want to scroll down on my item number 6, what do you ask? We just started to cover this. Okay, 6 on that. That Christina can supply to each of you. It says, how was title held? We just discussed that. Okay. Then next thing you want to know is, was it the deceased homestead property? Okay. And did they have a will? Okay. If they had a will, you want to get a copy of the will. Okay. And if they didn't have a will, you want to ask them, can you give me a brief family tree? Those are the questions that I'm going to be asking you. Was it their homestead? Did they have a will? And if they didn't have a will, can you give me a brief family tree? Now, This handout that I gave Christina is a wealth of information. In fact, Christina, if you could scroll down, I don't want to try to pull apart all the aspects, but keep scrolling down if you could for me. Keep going, keep going, keep going, keep going, keep going, keep going. I think the next page, if you could. Okay. Now, go back up to the Kelly's homestead paradigm. This is how complicated our state is. We have one set of rules that go up to the next handout, if you could. Yep. Keep going up. Keep going up. Keep going. All right. Yep. That one. Kelly's homestead paradigm. Go back down just a little. Okay. So we have a whole set of rules to somebody's homestead property on who it can be left to and who it can't be left to. And for those that are dealing with second marriages and wanting to leave their property to their kids, this becomes a very, very dicey subject, because either you have it's never an easy topic on how you dispose of somebody's homestead when it's a second marriage, because typically it is one of their more significant assets. And it depends on who it's going to, but the Kelly's homestead paradigm dictates for us is a very good summary of who we have to leave our home to. And generally speaking, if you have a spouse or you have minor children, you have to leave your homestead to your spouse or your minor children. Okay. So it gets complicated, but I share with you that there's a whole chart on how your homestead has to be disposed of. In most instances, people want to leave their homestead to their spouse anyway, so it's okay. If you scroll down, Christina, could you go down to I think 2 more pages down? Keep going. Now, this is non-homestead without a will. Non-homestead without a will. That chart would tell you who gets what when it's non-homestead. I'd like to think that I'm the author of these charts. I'm not. I found them online. They are correct. Please don't bust my chops if somebody claims it's theirs, but the bottom line, it's a good chart to be able to reference on who gets what. Okay. So if you call me and say who gets the property, if there's a will, I'm going to look at the will. If there isn't a will, I'm going to say who is the person survived to. Generally speaking, the short answer is spouse, if you have a spouse, kids, if you have kids, if you have neither of those, parents, if you have neither of those, then siblings. Okay. Sorry, I should say spouse, kids, grandkids. Obviously, it goes spouse, then down, then up, then out. So spouse, kids, grandkids, if not up to parents, then out to siblings. That is the intestate succession chart. So what do you do now that you've figured out who is, if we're lucky, you have a deed that avoids all of the probate process. If you don't have a deed that avoids the probate process, then that means that you're dealing with probate. So we look at the will, if we have a will, intestate, which means no will, to determine who's the rightful recipient. Now it gets a little bit more complicated. And I say that, and I do apologize to all of you. This isn't easy stuff, right? It's a very complex thing, and you guys might run across it once every 1 to 2 years. I have many, many files running across all at the same time. And so, yes, I have this stuff memorized. I don't expect it for you to understand everything that we're discussing, but if you keep my hand out and you have a probate issue, I bet you'll be able to find the answer in there. But if you can take away those items is look at the property appraiser, find out if the property appraiser doesn't have a deed that solves your problem, your title company, Julia at the title company can solve that for you. Okay, she'll be able to pull the deed too, but you'll be able to pull it, and she can tell you if you have a situation where you will need probate or won't. Okay. But then if you need probate, the questions I'm going to ask you are, was there a will? Was it the homestead? And if there is no will, I need a family tree. Okay, so now we know we have a probate that needs to happen. How does that work? And this is where I said it gets a little bit more complicated. When it is homestead property and it's going to lineal descendants, meaning it's going to family, okay? And I say lineal descendants, most of us think as kids, but in the eyes of the state of Florida, lineal descendants is a very broad window and means spouse, cousins. If it falls in anybody of that, generally speaking, umbrella of a family member, and it is homestead, then it will transfer directly to the recipients. And so the common realtor mistake I see is they put the estate of mom on the contract. And the estate of mom, if it's homestead property, won't actually be the one selling the property. The one selling the property will be the actual kids selling the property. Because if it's homestead and goes to family members, it's part of a probate process, but it's considered an exempt asset, which means the daughter isn't going to be the executor selling the home. It's going to be the three kids. No matter how much the daughter, let's say, wants to be the one in charge, she isn't as it applies to homestead property. And why does this matter to you guys? Because you need to make sure you get a listing agreement signed by all the kids. You see what I mean? You see how it all funnels back to you taking on that original listing. So if you call me, the first thing we're going to be discussing is who are the right people we need to make involved in this process, because normally it might be that daughter who says she thinks she's the executor, she's the one in charge. But of course, I'm going to say, well, wait, hold a second. If this is homestead and it's really going to all the kids, then I want all the kids signing, hiring me, and agreeing that I can get paid at closing, because I don't want somebody to be a holdout later. So just so you know, in our process, we advance all the fees and the costs and just get paid at closing in most of our cases, unless it's the bottom feeder investor, which even me, I'm sometimes a bottom feeder too. So don't, I'm not saying that I'm not one of those same investors too, but as long as it's a regular retail deal, we front everything, but we ask, because it's homestead typically, and it's typically going to the family, they're going to be all the ones selling it. So we might as well get them all on board. One, knowing that they're going to be part of the sales process, that they have to sign the listing agreement paying you. They got to sign my paperwork agreeing that I'm going to be taking my fees out at closing. So you and I, as the realtor, we're talking about this in the very beginning to make sure we've got an understanding who's going to be part of this process. Okay. Now, if it's non-homestead, different ball game. So it's really complicated when it's homestead. And I say it's not really complicated. There's just so many variety of rules that come into play when there's an executor and when there isn't an executor, and it's just transferring directly to the kids. Now, typically, what I'll do for you guys as the realtors on this process of selling a property is we'll say that Bob, Mary, and Sue are the three kids. They signed the listing agreement, and then we put under the additional terms of the listing agreement that it's subject to completion of the probate administration for mom. Okay. And then what we'll do is we'll do a sales contract. And normally I'll tell you, because we'll discuss it and have a powwow about the process in the beginning anyway, we will go through and I'll tell you, get that for sale sign on that property right away, unless of course there's a reason I say no. And we will say, listen, I already know what's going to happen. The judge is going to transfer this property to the three kids. get the for sale sign up there, make the contract with an end buyer with the three kids as the sellers, and put under the additional terms 2 items. One is the contract is subject to the completion of the probate administration for the estate of Jane Doe, mom. And I'll put, in addition, that typically tell you to put a closing date out 30 days, but that seller can extend the closing date up to an additional 90 days. Cash buyer. Okay. Now, why do we do that? Okay. In some counties, the judges will sign the orders right away. Some will make us wait the 90-day creditor period. Okay. So that's why I say extend an additional 90 days. So look, every county is different. Every judge's comfort level is different. In reality, the proceeds creditors have an opportunity to object to any claim that this property is an exempt asset. So I know we're kind of diving into some nuances here, but I could owe $100,000 to American Express, die, my kids get my home, and they don't have to pay the Amex bill because my home is an exempt asset and it transfers free and clear of any creditor's claims. So we will hammer that out with each client as it applies, but do understand that I don't want to pay bills. Okay. So we're going to try to keep every penny in the client's pocket, but sometimes there's a creditor process that has to happen before we give the middle finger to the creditor and don't pay them. Okay. So each situation is different. Sometimes judges sign off on these things quicker than they should. Sometimes some judges will say, no, I want the 90 days to run before and particularly Miami-Dade County, those judges particularly, they don't make any bending of the rules down there for us. They'll normally want us to wait the 90 days to make sure every creditor has an opportunity to be heard. So it all depends on the county though. So I have crammed a law student's 2 or 3 classes into about 40 minutes of probate into this. Does anybody have any questions? I mean, obviously there's a lot of nuances here, but I gave you a lot to think about. Does anybody have any questions? And make sure you take your mic and unmute yourself if you have some questions.
Does anybody have a question, guys? Or wants to clarify something? I know it's a lot of information. As Mike said, this is, probably new for some of you guys, or that we thought something different. From me, this quitclaim deed with the LLCs was a big eye opener of how to protect our clients, especially those of you who work with international investors that do this all the time. It's good to know this piece of information. Rosie, do you have a question? Mike,
Yeah,
yourself.
I want to
I
say,
do have one.
I want to say thank you so much. I have to run. I actually want to re-listen and write more notes. So thank you so much.
You
I
bet.
have to.
For those that didn't see, my contact information should be on that handout I gave. My office phone numbers 727-360-2771.
It's in the chat. I put his info in the chat. And of course, you guys know that this class is recorded. We'll have it in the YouTube channel probably tomorrow. So you can go and review. And I will send this PDF to the WhatsApp of the club just for you, those of you who had to run out. And Rosie, thank you for letting us know. But we will replay this for you in the YouTube channel. Madeline, you had a question?
Yes, I do. Good morning.
Sure. Hi, Maddie.
Hi. If the person, for example, there is this person that he died, and she was a sister of somebody, and she died, and she has no husband alive, but she has 2 sons. And they say, the sister says they do not want to have anything to do with the property. How do we proceed in that case to list the property? Did you understand?
So, yeah, well, I think I understand the general synopsis. So, and let me say, we often talk to family. We just got a case yesterday where we renegotiated the deal. Okay. So and so said they don't want to do it. And they don't want any interest, but they all agreed the sister was supposed to get mom and dad's property. Okay. Whatever the example is, it's something like that. Right, Madeline?
Yeah.
Is that, and
Yes,
essentially
yes,
what
that's
we do,
correct, Mike.
yeah, we essentially work a deal for them, meaning we will, if everybody tells, so if everybody tells me at the end of the day, we want Sally to have this property, then we make that happen. Okay.
Okay.
We will, and I say that, because sometimes it's in the form of a quick claim deed. Sometimes it's in the form of a beneficiary agreement. I mean, I had one up in the Panhandle that should have been a probate, but we ended up doing it as a deed reformation because we would open up a creditor period. So in most, we'll make it happen. We'll figure out a way to do it. And some of you are going to work with investors. Now, this is a really good one. And this is what I do is your investor is going to say, I found this property that's been abandoned and the daughter wants the property, doesn't want anything to do with it. How do we make this happen? Okay. You're going to get those sometimes. And then I'm going to ask you those same questions. Did the deceased have a will? And then what we do is we can do a greasing of the palm. We'll tell the daughter, we'll give you a check for 10 grand if you sign on the dotted line. And then I do the whole probate to make an investor be able to get a property for, whatever some people are more eager in that payday than they are waiting for a probate process. Okay. And we help package deal that up for the investor. We'll do all the leg, you find us the people that we need to find. We'll give you the documents. You get everything signed on the dotted line, and I'll help you figure out how to make a buck on it. So that's
Okay,
another.
sometimes we are, yeah, Mike, sometimes we are dealing with the fact that we have to make a contract and we have to specify the period of time. What do we do if we don't have that clear at that moment?
Well, in my example, I used a 30-day close and a seller that has a right to extend for 90 days. I did that intentionally because that would mean if in the situation is that it's going to be a quick probate, because sometimes we can get these done real quick. It depends on the judge. And we just hold the money for the 90 days. Then that's why I do that. The seller can extend it up to an additional 90 days. So we have a firm closing date 30 days after the effective date, but then have the ability of the seller to extend an additional 90 days.
Okay, perfect. Thank you so much, Mike.
So, any other questions?
Thank you so much. So usually the probate period, Mike, will be around 30 to 90 days, more or less, like altogether like 120 days at the most, if it's done properly from the beginning.
It depends on the situation. If it's non-homestead property, okay, then you can many times we can get it so we can sell within about 30 days. I mean, I would tell you, typically, I can have pleadings ready in 48 hours to go to court of being hired. I mean, so look, like I said, I work with realtors. In my opinion, we need the deal done yesterday. So I work extremely fast to get the probate documents done. But of course, I'm at the discretion of the court. In many instances, the judges will give us the ability to sell in about 30 days. Okay. Went through one form or another. Okay. But some instances, the judges will make us wait the 90-day creditor period. It's not always easy to predict because it's on a judge's preference. Some judges, if it's homestead, will simply say, we won't sign off on it till after the creditor period runs to see if somebody wants to challenge the homestead status. And so it depends if it's homestead or not. If it's homestead going to lineal descendants, I have no choice but to treat it the way the court, I can't dictate, meaning I can't say if it's homestead, I have to treat it through one type of procedure. I can't elect to treat it a different way. Do you see what I mean? And if it's not homestead, I can't cram it a different way. I'm stuck with what the rules tell me how I have to handle a certain property based on the type of property it is and who it's going to. And I can't cut corners. And I say that because I'm underwritten through First American and the fund, right? But all of these title examiners at your title companies are going to look at the work that I do. Okay. And I can't cut any corners because they're going to be double checking everything I do. So the only way to do it is the right way. So I have no choice but to do it the right way. And sometimes, depending on how it is, some judges make us wait the creditor period, some don't.
We
Any
have a
other
question here. Yes, we have a question in the chat, Mike. What happens if the person has no children, no family? That will go directly to the state if there's no will? Or
So
what would be the scenario, Aida? Is that the question, Aida, if you wanna ask yourself, or what would be the case?
Yes, exactly. Let's say that there is a couple, has no children, no family, brothers, sisters,
cousins,
nobody.
Give it to the realtor.
I have never had a probate yet that there wasn't somebody that the intestate statute told us who got the property. Meaning it doesn't go to the state.
Okay, but in this case, if they cannot find a person, I mean, if a husband and wife and one of them died and then the other one died and there's no family, no cousins, no aunts, uncles, or how do you address that scenario if there's not a will? Because I think, Aida, that the best solution in that case could be for that couple that don't have family to have a will saying, I want my state to go to a charity or to X, Y, and Z person. Wouldn't that be the right solution, Mike, in this case? If there's a will.
Well, yes, they obviously should have a will.
Yeah.
I mean, at the end of the day, the intestate law eventually ends up to the state of Florida. It does. So the answer is, when you say, does it end up in the state? The answer is yes. Eventually, it will end up in the state's hands. But in most instances, we can find extended family members. And unfortunately, that could get pricey because you're having to really hunt them down. And a nuance to that question is, if it's a couple, and this is a common occurrence, it's a couple, and then the last one to die is the girlfriend. Okay. It's not, and the deed was right of survivorship. We don't look at them as 50-50 ownerships. If the last one to die is the girlfriend, then we would go to the girlfriend's intestate succession, not 50% boyfriend, 50% girlfriend. So you always start with the deed too, to make sure we're chasing down the right family member. And unfortunately, what we see sometimes is these properties, multiple people die in the situations. That's the worst one. And this property, she died 10 years ago, and my parents never did anything. And my uncle never did anything about it. When the grandparents died, it's still under grandpa's name. And now we need to probate it. And now multiple people have died subsequent to grandpa, and we're having to probate multiple estates. It can be problematic.
Well, thank you so much.
Any
I
other
don't know,
questions?
Thank
any more
you.
question? Before we end the class right on time, this has been very, very valuable, Mike. Thank you so much for your knowledge, your time, and glad to know that you do in-person classes. We can set up in different topics, as you said, we can bring you back to the club. It's been a pleasure having you. I don't know if any of you guys wants to have a last question. If not, as I said, this will be in the club's YouTube channel, so you can review it, and the PDF will be sent also to the WhatsApp. So thank you again. And then, of course, be ready for August. The whole series of August is going to be very exciting. And thank you to Save Title. And this was, Mike was brought to us by Save Title from Julia, arguing that she couldn't join us, but we're very grateful that she was able to refer Mike to us to the club. Thank you again. And we look forward to having you in a different class with a different topic. I know that you're like a lot of knowledge that we need to go in more in depth. So thank you so much. We'll see you
You guys all
next
have a good
Wednesday.
day. Thank you for having me.
Thank you. See you next Wednesday, guys. Bye.
Good job.